Hello, my name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about data privacy and the Invasion of Privacy Act in California. So, California has a law called the Invasion of Privacy Act. It was enacted in 1967. The purpose of this law, and it was very forward looking, is that it was saying that because of advances of technology, there are ways that people could record information or conversations in some way about people, information about people in ways that may not be apparent to those people, and that they wanted to make sure that if that happened, that there would be adequate redress that that person could get. So this law, as I tell a lot of people who don't really understand privacy in California, California has a lot of privacy laws, and this is one of those laws. It's not under the umbrella, the bigger consumer protection law, the CCPA. In fact, this particular law has a private right of action per incident amount is $5,000. So this has been over the last couple of years become a very popular law under which people are trying to sue and get some redress. What's happening now in the internet age, and especially now in the AI age, a lot of suits that are being brought are saying that internet technology is being used in ways that create almost like an eavesdropping type of thing. So let's say someone is on their computer, they're doing something on their computer, and then maybe that data is being captured and used in ways that the person it may not be evident to that person. And so that third party sharing risk comes up with people. Even though a vast majority of these cases are settled out of court because it has a private right of action, many opportunistic people are using this particular law to file lawsuits. I think as more technology is being used in different ways, I think it's incumbent upon companies to think about the ways that that data is being shared, especially if data is being collected where the person is not aware. So whether that be a visual warning on a page, or some type of message on a page, or some type of information about how data is being retained, it'll be very easy for companies to fall into this gap around eavesdropping, because if if a company is collecting data from people and retaining data of people and using it, especially to be making decisions in a way that isn't transparent to them, this can be definitely be a really bad issue. I'm talking about California today, but there are many states that have similar eavesdropping type laws. A lot of these around who can hear certain conversations, recordings, whether that be audio or video, what type of consent or notice is required for that, and is different from state to state. But I think as we see more complication or more complex data systems being enacted, I think that more more people will lean into this particular law, and I think this is something that companies need to be more aware of, especially if they are implementing things that don't have the same level or the correct level of transparency, and then also being able to explain what technology is doing to people's data in terms of what's captured, what's retained, and what's shared down the line. That's it. Thank you.